Look, I'm going to be real with you right now. David Eby just pulled off something that takes serious political gymnastics. The man who literally wrote legislation to enshrine Indigenous rights is now standing in front of cameras saying, wait, not like that, after courts actually used that legislation to rule in favor of Indigenous peoples. It's like watching someone hand out maps to their house and then getting upset when people show up at the door. Welcome back to Canadian Insights, where today we're unpacking British Columbia's latest reconciliation plot twist that's got legal experts, Indigenous leaders, and pretty much everyone else asking, did David Eby just accidentally create a monster he's now trying to put back in the cage? Spoiler alert, this gets complicated fast, and yes, there's irony so thick you could cut it with a gavel. So here's what's happening in BC, and trust me, you cannot make this stuff up. David Eby, currently the Premier but formerly the Attorney General, is now publicly criticizing court decisions that relied on legislation he helped create. We're talking about the Declaration Act and amendments to the Interpretation Act, both of which embedded the United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP as the cool kids call it, into BC law. These were landmark pieces of legislation, celebrated as major steps toward reconciliation when they passed. Everyone voted for them. It was this beautiful Kumbaya moment in the legislature. Fast forward to now, and courts are actually using this legislation to make rulings. Wild concept, I know. The BC Court of Appeal overturned the province's mineral claims regime, citing the Declaration Act. The BC Supreme Court recognized Aboriginal title over both public and private land enrichment, invoking the same legislation. And Eby? Eby is out here calling these decisions judicial overreach, saying they could undermine public support for reconciliation, and preparing amendments to make sure courts don't get any more bright ideas about actually enforcing the laws he championed. The cognitive dissonance is absolutely chef's kiss level here. It's like baking a cake, giving someone the recipe, watching them bake the exact same cake, and then yelling that's not what I meant, when they serve it at a party. Eby's basically arguing that when the legislature enshrined UNDRIP principles into law, they meant it more as like a vibe, a suggestion, a framework for government-to-government conversations, not something courts should actually use to make binding legal decisions. Which, and I'm just spitballing here, seems like a pretty important distinction to make before passing the legislation, not after courts start using it. Now let's talk about what these court decisions actually did, because this is where things get spicy. The mineral claims regime case was huge. British Columbia has had this system where companies can stake mineral claims on land, and it's been a cornerstone of the province's resource economy for forever. The Court of Appeal looked at this system through the lens of UNDRIP and the Declaration Act and said, essentially, yeah, this doesn't adequately consult with or accommodate Indigenous rights. Boom. System overturned. Then we've got the Richmond case, which is even wilder. The Supreme Court recognized Aboriginal title over land in Richmond. Richmond? We're talking about a major city in Metro Vancouver with over 200,000 people, private homes, businesses, the whole deal. The court said the Musqueam Nation has Aboriginal title there, and cited the legislation Eby's government put in place as part of the reasoning. This isn't some remote area we're talking about. This is suburban Vancouver, and suddenly property rights that people thought were settled are back on the table. And Eby's response? Protect private property, this is government's job, not the courts. Which is a fascinating position to take when you consider that protecting property rights and interpreting law is literally what courts do. That's their whole thing. It's right there in the job description. But Eby's drawing this line in the sand saying reconciliation is political work that should happen through government-to-government negotiations, not through judicial decisions that could freak out property owners and undermine public support for the whole reconciliation project. Here's where the political calculation gets really interesting though. Eby knows, and his advisors definitely know, that public support for reconciliation gets real shaky real fast when people think their property rights are at stake. British Columbians might be on board with land acknowledgements and treaties and symbolic gestures, but the second you start talking about Aboriginal title over established cities, suddenly everyone's got concerns. The government's looking at polls and focus groups and seeing homeowners in Richmond and beyond absolutely losing their minds, and they're thinking we need to get ahead of this before it becomes a political disaster. So Eby's planning amendments to both the Declaration Act and possibly the Interpretation Act when the legislature reconvenes in February. He's promising these amendments will clarify what the legislature really meant when they passed this legislation. They'll make it crystal clear that this was about government commitments, about partnerships with First Nations governments, about doing the work together, not about giving courts new tools to make sweeping decisions about property rights and resource regimes. But here's the problem, and it's a big one. Indigenous leaders are already warning the government not to water down the legislation. They are saying that walking back these protections would undermine reconciliation, which is exactly what Eby claims is trying to protect. It's this impossible catch-22. If Eby doesn't amend the legislation, courts might keep making decisions that freak out the general public and erode support for reconciliation. But if he does amend it to limit how courts can use it, his signaling to Indigenous peoples that the government's commitment to UNDRIP was conditional all along, dependent on courts not taking it too seriously. And let's talk about the legal logic here for a second, because it's genuinely fascinating in a constitutional law kind of way. When the legislature passes a law, courts interpret that law. That's the deal. That's how our legal system works. Courts don't just rubber stamp what politicians say the law means, they read the actual text, consider the context, and make determinations. The BC legislature passed laws that embedded UNDRIP principles. UNDRIP includes provisions about Indigenous rights to land, resources, and self-determination. Courts looked at those laws and said, okay, this means Indigenous rights need to be taken seriously when evaluating existing systems. That's not judicial overreach, that's literally just judicial interpretation. But from Eby's perspective, and you can kind of see where he's coming from even if you disagree, the legislature thought they were creating a framework for negotiation and partnership, not legal ammunition for court challenges. They thought they were setting direction and values, not creating enforceable standards that would override existing legislation. The problem is they didn't say that clearly enough in the legislation itself, and now courts are doing what courts do, which is read laws and apply them. The mineral claims regime case is a perfect example. For decades, maybe centuries depending on how you count, BC has operated under a system where mineral rights could be staked with minimal Indigenous consultation. That system predates UNDRIP, predates modern reconciliation efforts, predates a lot of contemporary understanding about Indigenous rights. But it's also a system that underpins huge chunks of BC's economy. Mining companies, investors, workers, whole communities depend on some level of predictability in how mineral rights work. The court basically said that system doesn't comply with contemporary legal standards around Indigenous rights, and now the government has to figure out what comes next. Eby's looking at this and thinking about all the other systems in BC that might not comply either. Forestry regulations, water rights, land use planning. There are potentially hundreds of established legal regimes that could be challenged using the exact same reasoning. And if courts keep ruling that these systems need to be overhauled to comply with UNDRIP principles as enshrined in provincial law, you're talking about massive uncertainty, massive costs, massive political headaches. So from a pragmatic governing perspective, Eby wants to close that door before it swings wide open. But here's the thing that makes this such a minefield. Reconciliation isn't supposed to be easy or comfortable or convenient. It's not supposed to be something we do only when it doesn't cost anything or inconvenience anyone. The whole point is addressing historical wrongs and recognizing Indigenous rights even when, especially when, it's difficult. If the government passes legislation enshrining Indigenous rights but then walks it back the moment those rights actually matter in court, what's the message? That reconciliation is fine as long as it stays symbolic? That Indigenous rights are valid until they conflict with settler interests? Indigenous leaders are making exactly this point. They worked with the government on this legislation. They celebrated when it passed. They believed it represented a genuine commitment to implementing UNDRIP. And now the government is preparing amendments to clarify that actually, maybe not so much. The trust damage here could be enormous. Every future negotiation, every future partnership, is going to have this shadow hanging over it. If the government's commitments can be walked back when they become legally meaningful, what are those commitments worth? And there's another layer to this that's worth considering. The courts that made these decisions aren't activist judges trying to impose their political views. They're interpreting the laws the legislature passed using established legal principles. If the legislature doesn't like how courts are interpreting their laws, they have the power to amend those laws, which is exactly what Eby's planning to do. That's how the system works. But that doesn't make it not awkward when the person amending the laws is the same person who drafted them in the first place. Vaughn Palmer, veteran political columnist, has pointed out this irony beautifully. Eby, as Attorney General, amended the Interpretation Act in ways that increased the likelihood of UNDRIP-based challenges to existing legislation. Now as Premier, he's criticizing the results of his own handiwork and preparing to amend the legislation again to prevent exactly the outcomes his previous amendments enabled. It's like watching someone build a ramp, watch a skateboard roll down it, and then blame the skateboard for following gravity. So we're heading into a February legislative session where BC is going to have some very uncomfortable conversations about what reconciliation actually means, how far Indigenous rights extend, and whether laws mean what they say or what politicians wish they'd said. The government's preparing an appeal on the Aboriginal title decision in Richmond, which could take years to work through the courts. They're drafting amendments to make sure future court challenges don't have the same teeth. And Indigenous leaders are mobilizing to defend legislation they saw as hard-won progress. The really tricky part is that there's no clean answer here. You can simultaneously believe that reconciliation is crucial, that Indigenous rights need to be respected, that property owners shouldn't face massive uncertainty about their land, that resource industries need some predictability, and that courts should interpret laws as written. All of those things can be true at once, and they're all in tension with each other. That's what makes this so complicated and so fascinating. Eby's betting that he can thread this needle, that he can amend the legislation in ways that calm public fears about property rights while still maintaining the government's commitment to reconciliation. He's betting that Indigenous leaders will ultimately understand the political constraints he's operating under and that public support for reconciliation requires managing expectations about what it means in practice. It's a high-wire act, and honestly, it might not work. What do you think? Is Eby right that courts are overreaching, or is this just the sound of chickens coming home to roost? Should legislation be amended to clarify limits, or does that undermine the whole point? Drop your thoughts in the comments, because this is the kind of issue where reasonable people genuinely disagree, and I want to hear all sides. And hey, if you're still here, clearly you're invested in Canadian politics at a level that's either admirable or concerning, so smash that subscribe button for Canadian insights. We're cranking out videos all day covering every twist and turn in this beautiful mess of a country's politics. Hit the bell, stay informed, and remember, reconciliation is complicated, property rights are complicated, and trying to satisfy everyone simultaneously is basically impossible, but watching politicians try is absolutely riveting. See you in the next one.